Yes, yes, you are very much audible.
Thank you, sir. Very good evening to one and all. This is Rehan Ghalib on behalf of Being Logical and JLSR Journal. Apratim De sir is a young enthusiastic lawyer who has a keen interest in legal research and writing. He has completed his Bachelor in Law BLLB from New Law College Bharati Vidyapith, deemed to be University at Pune. During his law school days, Apratim sir was an active mooter and had participated in various prestigious national moot court, trial advocacy, and client counseling competitions, and his team has bagged runners-up position in two of the moots and adjudged as the winner of the client counseling competition organized by SDM Law College, Mangalore in 2020. Apart from this, Apratim sir has a keen interest in legal research and writing and has presented 2 research papers in national conferences and has published 2 research papers in national and 2 research papers in international law journals as well. His areas of interest are corporate and business law. Over to you, sir. Now we can move further.
Okay. Thank you so much, Rehan, for the lovely introduction. And before we begin with today's session, very good evening to all the participants who have joined us today for this session. And I would also like to thank JLSR Law Journal and Being Logical for giving me this platform to deliver a lecture on the topic legal research and writing, which is, a very important topic and an integral, an integral part of your law school life, which would carry on with you even, in fact, when you enter the profession until the time you continue practicing law or you go in academics for that matter. So having said that, today's session will be divided into 2 parts. The first part, we will talk about the legal research, the nuances of legal research, and the usage of legal research during our law school days, as well as during the internship and as well as when we practice law. And after that, we will move on to the writing part, which is again, bifurcated into various parts like research paper writing, article writing, blog writing, and above all that also, how do you improve your writing skills or how do you improve the quality of your manuscript? So basically, at first, I would like to talk about, what is research? If, when we hear the word research or legal research, what is the first thing which comes into our mind? That, searching for case laws on SCC or Patra or visiting the websites of various concerned honorable high courts, supreme courts, and the trial courts, and pulling out case laws from there for the the relevant judgments you are looking forward to. But having said that, let's understand what does research in itself means. So basically, research is a careful and detailed study of the subject to cover or to discover new facts, new information, and to have a better understanding on the subject in question. So research is basically nothing but a way forward study of a topic or a question which you have in hand, for which you are seeking answers, or for which you want to look forward into or move ahead into, or to find new and let's say unknown, lesser known or unknown facts which you still don't know about the subject matter. So that is what we can say about research in general. Then moving on to what is legal research. So, now legal research is a bit different from the general research. Why? Because legal research is the process of identifying and retrieving information necessary to support legal decision making. So now, let's break this line into several parts to understand what legal research actually is. Having said that, there is a lot of confusion which I have seen amongst the law students, where they actually mix up legal research and legal research methodology all together into one. No, both are, totally a different subject matter. Like what we are going to talk about today is legal research, and legal research methodology is more technical, more comprehensive, and it's in a more orderly form, which you normally get to study when either you are doing post graduation or even during your graduation, if you are lucky that your college has a curriculum that in the final year you'll have to submit a dissertation. So at that time, you actually get exposed to what legal research methodology is. And apart from that, there is, a huge difference between academic research and the research which we use in the law practice. Actually, there is a, there is a gap of, there is a lot of gap between the two kinds of legal research, because you see, one of the legal research comprises of both theoretical and practical aspects, the first one, and the second one, demands more of, some hacks and skills which to extract the relevant information in the lesser time possible or in the least possible time. Because see, when you will go for internships, or if you have done internships, I'm assuming that the people who have joined us today, most of you have done at least one internship in your law school. You are in second year, third year, fourth year, fifth year, which year you are in, irrespective of that, or you are a pass out graduate, you have at least done some internships during a law school journey yet. So you will see that many a times what happens is that you get a lot of time to research on a certain proposition, but sometimes it happens that you have to think on your feet, that your senior says that I want a particular judgment on this particular question of law in next 1 hour or next 2 hours. So if you go by the methodology of academic research and you try to apply the said research methodology over here, then I'm sorry, my friends, you will never be able to achieve the desired results. Okay. So please understand that academic research, which you mainly use for, writing research papers or writing articles, blog publications, that's one kind. The other kind which you use while practicing law, that's an other kind of, other kind of research, to say that the procedure in both the types are quite different, which we will discuss further in today's session. But having said that, why do you do legal research? To substantiate your argument or to prove your contention or your hypothesis. I mean, when you are making an argument before the court of law, you cannot merely go before the honorable judges and state the facts. You will have to substantiate those facts by using point of law, by using case laws, by using statutes in picture, and other sources of law which are there on that particular point. You cannot simply go and state the facts over there. What happens is, like, people say that doing moot court in your law school days gives you an edge over others who haven't done moots, because it makes you ready somewhat to the practical aspects, which is true. Because when you do moots, I'm not talking about trial advocacy. See, moot courts and trial advocacy are very different, but I would suggest that moot court involves, more of your brainstorming and forces you more to think on question of laws, how to apply the statutes, how to apply the case laws. That's what, the moot court helps you to enhance your research as well as thinking skills on that. So having said that, in short, we would summarize that what legal research is. The legal research is, done for the purpose of, finding such information, relevant case laws or the statutes which are there into picture, to make your arguments which you are going to put in the court of law more authoritative, brings a positive aspect before the bench, that the counsel has done a good research and he is talking something related to law. Because on facts, even an ordinary person who is good in arguments, they can also argue. But you as a lawyer, a law student, or a research scholar, or a jurist, you differentiate yourself from others at a point when you actually, bind your arguments with good, thorough research, putting relevant case laws, or the relevant notifications, circulars, etc., whichever way you decide to prepare your case. So that is how a legal research is different from an ordinary research, as we talked about just now. Now the question comes that why you should do legal research, or to put the question in other way, that why one should do legal research, why one should learn legal research, that what is the need of learning legal research, right? there has to be certain objectives which you have to determine to answer these questions. So the first point is to support legal decision making, which I already talked about, that if you are giving an argument, you are preparing for your case, you are making case briefs, or you are trying to defend your client in the court of law. So in that particular case, you will have to actually support your arguments with good research. So that is why you should know how you do good legal research in order to support your decision making, in order to improve your decision making, in order to improve your approach, in order to arrange the case in the manner you want to present it before the judges. Then to find answer to the complex legal issues, of course, because see, normally what happens is that when you will go to internship, you will see that the law which we read in the law school, like the bare reading of the statutes or the bare reading of the bare acts, and actually you will see that there is a huge difference when you apply those the things which you have read during your law school, the laws, the bare acts, the laws in the textbooks, case laws you have read, you get the opportunity to apply. But during the application, you will see that mere reading of those statutes, or merely just mugging up those statutes from the bare acts won't help you or serve your purpose. Rather, you will have to read different judgments which the honorable courts may have passed on that particular point of law you are looking at. So you will have to read those judgments. You will have to understand that what is the mindset of the honorable judges who have pronounced the judgment. You will have to go into the facts of those judgments. From there, you will have to deduce that whether the issue which you have in hand is related to the case which you have found. Is it relevant? If it's relevant, how? If you have to build a nexus between the two. So for that, legal research plays a vital role, because there your bare act reading or your textbook reading won't help. You have to research in the commentaries, you have to research in the digest notes which are available on the various legal search engines like SCC Online, Manupatra, Heen Online, JSTOR, etc. There you will have to do a thorough research to understand, that particular point of law or question of law which you have in hand at that point of time. Then to understand the statute, of course, again, this is already covered by me in the second point, that and how do you understand the statute, and how you have to do further research to understand the statute. See, when, as I said, take up a bare act. If you don't believe me, take up a bare act which you have of any laws concerned. You have a basic idea about that law. If you have studied in your law school, read the bare act language, stop. Then read the same section or same statute from a textbook on the such subject matter. You will see that you are able to understand the textbook language, but you are not able to understand the bare act language which is given completely. So what happens is that what the actual talent of a lawyer or actual work of a lawyer is that not to understand the textbook language, but to understand what is written in the bare act language. Because when you will be, many a times that happens, generally people make mistake that they go by the textbook language. Many a times in the textbooks, many crucial provisos or, the important parts of a section is not very well explained, or if you see, they many a times omit the particularly the proviso or a complicated part which they are not able to comprehend. So in that particular case, you are going with half-baked knowledge. If you missed out a proviso, or you missed out even one line, one word of the bare act section which you have read, then your case is gone, because you may have left the important proviso which would actually, if you have read, you would have understood that no, this particular section doesn't apply in my case. Okay, that proviso would have been that much important, and as you omit that just by reading textual book, you will be in a very much big trouble, you and your client, that you applied a wrong section which was going against you. You applied the said section in your matter. So that is why it is important that you do a proper research. And if you are not able to understand the bare act language, go refer to SCC, the digest notes given there, study those notes further, and then try to understand that what the statute is saying. Then to understand the position of law, that let's say if you are discussing about the introduction of capital punishment for the crimes committed against women. Okay, like rape. If rape is committed against a woman, then capital punishment should be introduced. That is what some people holds the position on. Now, if you have to make a choice, or if you have to decide that whether capital punishment would be apt for crimes like this, or whether it will be it's a valid thing to do so. So you will not just decide by listening to what newspaper reports are saying or what a person is saying. You will have to actually read the law on what are the punishments already in existence regarding rape. You will have to read those laws. You will have to make a call for yourself after reading and understanding the laws, relevant laws, that whether these laws are enough to curb that crime or not. Then if when you have made the call that yes, the laws are enough, or no, the laws are not enough, then you'll have to go into the pretext that why this particular law was made like this, or what was the idea of the the lawmakers or the legislators when they legislated this particular law. Okay, you will have to see that. You will have to understand that, okay, if you are disagreeing, if you are feeling that there are some shortcomings, why those shortcomings are. Then you will have to further research on the current crimes which are happening in the country against women, and because of which there is a lot of demand that the law should be more stringent. Then after considering all these factors, you will at last come into the consideration that, okay, we are living in a society which is not static, it's a dynamic society. Laws has to be changed and has to be adapted as per the situation which is there in hand. Like if the situation today is more critical than before when the law was actually enacted or imposed, so today you need to legislate or make amendments in the existing laws. That is how you will understand the position of law on a current issue in hand. Then to seek complete answers. Of course, why do you do research? Because see, initially you have taken up a problem, you don't understand some parts of it, or you think that the understanding which you are getting is half, or it's not you are not satisfied with whatever let's say arguments you have in hand, or whatever the points which you have in your hand regarding the issue which you are dealing with. So you will have to do further research to satisfy yourself and to reach to a point where you can say that I'm satisfied with the answer which I have received, and now I can move ahead with my case. So for seeking complete answers to the issues in hand. So now the steps in research process. So in this part, I will discuss both the things hand in hand, that how to do research for a problem which you have in hand, and how these steps are very useful while you are presenting your research in a form of a manuscript, be it an article, a blog, or whatever kind of a manuscript you are intending to write, a thesis, dissertation, etc. Okay, so the first step, or the crucial step which is involved in the research process, is that you need to choose the research problem very carefully, my friends. Because what happens is that when many a times I have seen that my colleagues and my juniors, when they have approached me that they want to write a paper on a certain issue, or they want to do a research on a certain issue, so they face a problem in selecting the topic or the problem for the research on which they would carry forward their study. Why this happens? Because normally how we all choose topic, I don't know about all, but most of us I have seen do that we actually go on Google, we see that what are the trending topics which are going on right now, and we just simply select that as our research problem. This is the biggest mistake you will be doing if you are doing it so far, or you are doing it in future. See, Google is helpful to you for taking a preliminary idea about a topic. If you are all if you are totally nil, or you are having zero idea about what the topic talks about, in that particular case you can do Google. But if you have some basic idea, then go ahead with that idea, take a bit of introductory knowledge from Google, the preliminary knowledge, and then start brainstorming. Because whenever you are selecting a good research problem, it will be a good problem only if it has been less studied by, or in regards to that problem there is very less information which is available right now. Always choose such a topic on which there is still a lot of opportunity available for exploring. Otherwise, nobody is going to read your manuscript if you are going to just select a topic on which every other second, third person has already written a lot of article and blogs. Why would someone, you think for yourself, why would someone like to read a blog on which already a lot of information is available? Nobody would like to read, because the scope of researching ends over there. So you will have to see that the kind of problem you are choosing, in that how much scope is there to research, to explore, to substantiate, and put your own points into that. Okay, that's number one. Then number two, framing of title. Now choose your title very wisely, because just to make it attractive or catchy for the readers, you choose some title which you are not able to justify later on, or the title of your research and objective of research are totally poles apart from each other, no nexus is there between them, then it's again a failure on your part to make a good manuscript. So choose your title, frame the title properly, try to establish a nexus between the title of your paper and the hypothesis or the objective on which you are starting your research. Build a nexus between these two things and then move ahead with your research. Then next is framing of issues. Of course, as I just now told you in the first point itself, that framing of issues plays a vital role. Your framing of issues will determine that whether you are going to talk on point of law, or you are simply just going to talk on a normal socio-legal issue, let's say, or sociological problem. That's what it will be determined through your issues. So make your issues properly, deliberate upon your issues at least 5 to 6 times. On each issue, deliberate at least 5 to 6 times, and make sure that the issues which you are choosing, you are able to end the paper with those issues. Because many a times what happens is that we choose one issue, we write something else in the body of the paper, or the content, in the main content we write something else, and by the time we reach the conclusion and way forward, the content becomes something else. So 3 different phases comes. Topic is something, issues are something else, justification for issues are totally north to the issues which is actually in the picture, and conclusion is all totally different. So you started the paper from Jaipur, you wanted to reach Delhi as your conclusion, but you reached Mumbai. That is what happens. So try building nexus amongst all the points which I have jot down over here. There should be a connection between all of them. They should be related to one another. Okay, then deciding the research methodology. So now, as I told in the beginning only, that academic research, practical research are quite different from one another. So if you are you are a law school student, undergrad student, you are doing, some research paper for your assignment or for your, blog publication, manuscript publication, etc. Use resources like the good research papers which are available on the said matter, opinion of the senior advocates, jurists on that particular topic. Then you can choose the commentaries, case laws which are there in the picture. All these things you can, opinion of judges, etc., you can use. But when you are a postgrad student, when you are intending to write a thesis or dissertation, so guys, make sure that you just simply don't stand by the textual material, especially if you are intending to do a LLM or a PhD and intending to become a research fellow or a law faculty in future. So you have to be very diligent with your work. Textual materials are to be referred, but they are not the final objective. You will also have to refer to practical data. You will have to do data sampling, you will have to do data collection. From that you will have to refer to the what should I say, the data which is available in the form of graphs. And you will have to refer to the studies is a document containing hundreds or thousands of pages. Nobody is going to read that much document because nobody has that much time. So make sure that you gather and process the data carefully. Then moving forward to conclusion. Now, guys, understand one more thing, that there is a huge difference between conclusion and way forward. What conclusion is like whatever discussions you have done throughout the paper or throughout in your manuscript, that you summarize it, concise it in a few lines and put it as a part of your conclusion. And way forward is basically the suggestions that the research you have conducted and the shortcomings which you have found during the research which you have conducted. So on the basis of that, how do you overcome those shortcomings, that you have to put in way forward. Don't mix conclusion and way forward. Many people do this. Just keep conclusion segregated from way forward. Then lastly, do literature review. So why literature review is important, guys, is because normally what happens is that you might be thinking on a research problem from one perspective, but when you do a literature review, that is reading up the work of other people on the same topic, I am 101% sure that you will come up with a new perspective which you haven't thought about back then. So always try to do literature review. That will improve the quality of your paper. Apart from that, it gives you, a new perspective or edge over the other write-ups which are there. It helps you to understand, to, see or to determine that what all issues which are still there. Like from literature review, you can go exactly to point number 3, that is framing of issues, and you can solve the problem of framing of issues. Like many times you don't get a proper issue, or you cannot frame a good research hypothesis or an issue for your research paper. So in that particular thing, what happens is that after you read the work of other people on the same topic which you are intending to do research on, you get a clear-cut idea that, okay, these are the areas which has already been explored, these are areas which are less explored, these are the areas which are still to be explored, or the hypothesis which this person has quoted in his or her work, I don't agree with it, and I want to find a new perspective to this. So this is how the literature review helps you. Then moving on to objectives of legal research. So see, the objectives of doing research is very simple, that first you do research to find out the lacuna or shortcomings which are already existing on a given hypothesis, and and you prepare points, you do further research to find out some suggestive steps with which you can overcome these shortcomings. Then to come up with a new legal concept. Many a times it happens that while doing your research, you try to build, you try to prove your hypothesis, or you try to defend your thesis or dissertation. So at that point of time, you come across new legal concepts, which is not only helpful to you, but also helps other people, in our profession. Then to analyze the law from the point of view of history. Of course, when you are doing research, as I said, that as I give you example of capital punishment, that is how it is, that when the legislators frame new laws, or when the people suggest, the experts from whom the legislators seek guidance, when they inform them about a new approach, so at that point of time, the analysis is being done by those experts, not only from today's point of view, but also back in law, back in history, when the law was first imposed, or what was the idea with which that particular law was imposed, and looking also at the future effect of the application of that said law. So that is how to analyze. The analysis of law from the point of view of history is very important. If you will read legal history, there's a subject in many law schools called legal history. So you will be able to understand that how the judicial system which we have in our country today has been adopted from the judicial system which was there in the past. Like today we have civil courts and criminal courts. Even in the past there was Sadar Diwani and Sadar Faujdari Adalat, there was small causes court. All these things were there in the past also. So to understand the purpose, or how these courts were established, or to determine the jurisdiction, that why a civil court of senior division judge, civil judge senior division has a pecuniary jurisdiction of certain amount, and why the court of civil judge junior division has a pecuniary jurisdiction of certain amount. So that you will understand if you go back to the history and you read it, and you will understand that on what basis back then, when it was the erstwhile pre-independent India, how was the entire territory of India divided, and on what basis they have divided the jurisdiction. So if you are interested to know that, you will have to go back into the history, and you will have to study the subject legal history. Then to explore, to examine the nature and scope of new law. Of course, because see, when you will be, studying, when you will be doing research, so it will also help you to examine, the scope of, let's say, the existing law which is there. So what is the scope of improvement in this law, or in order to prevent an XYZ kind of a crime, what are the new kinds of, limitations or new kind of riders which can be put upon the, criminals to reduce these crimes? What are the new kinds of law which can be enacted to, smoothen or ease the problem which currently we are facing, and because of which the need for establishment of new law has come up altogether. Okay, then to, of course, to ascertain the merits and demerits of old laws and to give suggestions for a new law. Of course, that's very common. I don't need to explain this point. That, of course, the research will obviously tell you, will force you that to find out what are the pros and cons of an existing law which is there in hand. Then lastly, to develop the principle of interpretation of critical examination of statutes. Of course, I told you, reading a bare act or reading the bare statute language, you won't understand what the law says. So you'll have to do further research to interpret the law, to understand the law. Now, the favorite part, I think most of the people who have joined us today are law students or final year law students, okay, or are pursuing their LLMs. So this is, the part for you people, that how, like, what is the importance of legal research in your law school? It is important for assignments and projects. Of course, without good research, you cannot, forget about winning a moot. You cannot even start doing a moot. Then, of course, for debates, internships, research papers, dissertations, thesis. So amongst these, I will discuss only a couple of points because the others I've already discussed. So in moots, you already know that in moots how research is important, because you are given a problem, which is based on certain facts. Question of law is involved in that, but you will have to deduce it, that how you will determine the question of law from those raw facts which are given to you. Again, you will have to find that what are the relevant facts applying to your moot prop, and what are the irrelevant facts which are given just to confuse you. Then you will have to find relevant case laws on the issues which you have in hand. And the best part in moots is that, moot, trial, advocacy, whatever kind of competitions we have these days, the issues are already being framed. Okay, so that is where your 80% job is done. Framing of issues not required. Now you just have to substantiate those issues that you do by finding relevant case laws, relevant statutes on the point, or reading commentaries for that matter. Then in debates, actually, very sorry state of affair, and I'm sorry to say this, but most of the times you will see that people debate without doing a good research, and which end up into a quarrel. So again, if you want to do a good quality debate, do a proper background research on the topic. Then in internships, I've already discussed, and I'll again discuss a little bit in detail about how research helps you in internship, of course, to build your case. If you are, working with a senior who trusts you a lot and gives you the responsibility of building up a case brief from the scratch, then this is very much helpful. Okay, the legal research is very much helpful. You will get the opportunity to give suggestive issues to the court. I won't say that you will frame the issues and give to the court, because that doesn't happen. After getting the problem, after admitting the appeal or the petition and hearing both the parties, the court actually frames the issues. You can just give them suggestive issues to tell them that, to request the judges that if they can, put some issues which you feel like are, left behind in the issues framed, or you feel like that would give a better edge to the, or would do justice to the case in hand, then you can give them the suggestive issues. But it is again upon the honorable judges to decide whether they want to incorporate those suggestive issues or not. Then apart from that, there are other factors also there in internships. Like if you are doing a CS company secretariatship internship, then you will have to see that, the thing is that you will see that they will be very much into this thing. When you are going for this internships, that they do a lot of compliance related work for which they need to relate to the circulars and notifications which are there in hand. Then of course, for research paper, we already had a lot of discussion. Dissertation, thesis at your master's level, for that research is really important. Okay, then the next one is that, so research involved during internship. So first, You will have to study the brief thoroughly. You will have to take quick talking points, prepare a list of dates, and you will have to put a quick. You have to segregate the relevant and irrelevant facts quickly after reading the problem. After reading your case brief, okay. Then you will be start researching, or you will start analyzing those facts, and after analyzing the facts, you will frame the suggestive issues, or you will identify the issues in hand. Then you will try to do justice to those issues by finding the relevant case laws or statutes which you have in the picture. And lastly, you will substantiate your arguments by using proper legal authorities. Of course, the concerned statute which is there into the picture, and you will research case laws on SCC and Manpatra the way it goes. Then the tools to be used for internships, statutes, the first resource which you have to do your research on, or the base from where you start doing the research. Because if you get a research problem or a case which is totally new to you, and you don't understand that how to start building your case or how to start with the case, so you will first start reading the statutes. You will understand the bare act language, like if certain sections are applied in your case, you will read that section from bare act. Then you will open a commentary, and from commentary you will read those sections, and then you will move ahead with the your research. Then after that, you can, if you are thinking the commentaries are very bulky, you have very less amount of time, and a lot of work has to be done in less time, then directly refer to digest notes which are available on CCM Manupatra. Then you can you can find the relevant case laws by using the appropriate keyword, because most of the students have a problem that we don't find the relevant case laws in the question. You need to, the problem, research problem which is given to you, from there you will have to find the relevant keywords which you directly put into the these search engines, and you can start ahead with. Then you can use for the academic purposes, you can go to this Pulvar, Mondak and JSTOR, these blogs you can go. From here you can get, you can directly download free research papers. But in JSTOR, I think there is some limitation given that you can download only 100 papers or something. I don't know, on one ID actually. 100 was the limit if I'm not wrong. So these are some free, search engines which you can refer to, or the blogs which you can refer to, because in Mondag, normally the partners of the law firms in India, they write their opinion on a certain issue or a certain legislation which has been made, or a certain case which has been made. So it gives you a lot of practical insight from the application or practice point of view of the same. Then legal writing. So for a to make your paper a good write-up, you will have to basically find out all these things. That firstly your research has to be a detailed research, so that you yourself is sure that whatever you have researched, and after doing the research, whatever you are contending in your paper, in your manuscript, that's the best information which you have deduced to your knowledge, and you will be able to defend it in case if it is required. Then you have to then study of the law and statute as a whole. As I said, that in order to make a good paper, you will have to study the law and the statutes properly, without just relying on whatever is given in the articles or the news clippings, or in the e-articles which are being published by the newspapers. Don't do that, because you will not get the actual context or idea of the study of law in that. Then misinterpretation. If you have any confusion after doing or referring all these resources and research papers, you are still having a problem, you are getting an apprehension that you are misinterpreting the law, refer your senior, a senior who is a practicing advocate, or your law teacher. Refer them and clear your misinterpretations, but don't write something which you are not sure about. Then your paper should, of course, your writing should, of course, depict the clarity of thought, that your thoughts are very clear. You have a very clear idea, clear mindset while you have chosen the topic and what you have written about. Don't get confused or don't beat around the bush. Okay. Then expression of thoughts on the point. Again, it is similar as clarity of thoughts, that whatever points you are making, they should be crisp, precise, less, and should be clear. If a reader reads those 3 lines or 4 lines, he should be able to understand that what point you are trying to make, instead of writing 10-15 lines on a small thing or small issue in hand, and the reader is getting confused and not able to understand what you have written. Cite properly, because if you won't make the citations properly, then it will attract a lot of plagiarism in your paper. and a good experienced scholar, research scholar, law teacher, or a professor will be easily able to determine that you have not written your paper properly or a quality paper, because citations matters. That shows that how much research you have actually done and how much study you have done for the given topic in hand. Lastly, known to everyone, please avoid plagiarism. Don't do plagiarism, because people think that they might easily get away by doing a copy paste of other person's work. But trust me, guys, the authority to whom you have to justify your paper or justify your the writing which you have done, they are dealing with thousands of such papers every day. Trust me, they will in a second find out that you have plagiarized your paper, even putting it in a software like Turnitin or other paid softwares which are there. So it also tarnishes your reputation if you are doing plagiarism. It shows that you have done no efforts, you have made no efforts, you just simply copy pasted it. And I know that after the end of the session, one question will obviously come, sir, how to avoid plagiarism? To avoid plagiarism, read, extract information through your research, understand what you have researched, then write it in your own words on your own. That is the only way to avoid plagiarism. And you say, sir, if something is held in a judgment, how do we avoid plagiarism in that? Then, guys, for that, you have to understand that you don't quote exactly what the judges have said. Rather, you read it, you understand it, and you deduce it in your language for making it readable to others and to avoid plagiarism. And if there is some quotation which is there, put it in bold, italics, under inverted commas. That's the shortest hack to avoid plagiarism. So with that, I think we come to the presentation part of this session. Now, if you have any questions, please feel free to ask.
Thank you, sir, for showering all the legal approaches and the different interpretation of the statute. We have received certain question from the participant. I'm putting to you.
Yes, please go ahead.
Sir, first question is, highlight the legal actions, punishment under the IPC that will be taken against the research misconduct, fraudulent case, plagiarism issues if brought into the notice. That's the question, sir.
Amresh, it's a lot of things put into one question. So what I can understand is that the person wants to know that what are the consequences if you are doing a plagiarism, right? That's I think the easiest thing which I can understand the entire question. So moving ahead with it, see, under IPC and as such, there is, I'm so sorry whoever has put this question, I don't know, but there is no such punishment as such for plagiarism under IPC, guys. It is like that if you are doing a plagiarism, your academic work will directly get rejected. If you are doing a PhD and if you are submitting your thesis which is plagiarized, they might withhold your degree. They might not give you your PhD, right? Because you have plagiarized and you have not made any efforts to do your work. Apart from that, if you are writing for a good journal or a blog, they might blacklist you. They might, put your name permanently in the list that you are a kind of a person who is into plagiarism and who is into stealing others' work. So they might blacklist you and they will never accept a submission from you. So this is, I think, something which can happen at most. But so far, I haven't understand that if, I haven't heard that if anybody has been penalized under IPC for that matter to, for writing or plagiarizing someone else's work. Okay. So I think Rehan, that was only the question, right? That what is the punishment for plagiarism under IPC or something like that, right?
Yes, sir, that was his question.
Okay, good. Then move ahead. Next question, please.
Next question from the same participant, sir. Is the law in action with respect to legal action to be taken on fake predatory journals?
Fake predatory journals. I mean, see, I don't know that if there is particularly any law into picture for predatory journals, but of course, I think like if you have taken, if there is a XYZ journal which has taken money from someone and had not published their manuscripts in that journal and have just ghosted away with that money, so you can file a case for like a, what should I say, maybe for a forgery, or that like he has taken away your money. That is something at most I think you can do. Because I think apart from that, there is always recommended that if you are going to publish a paper in a journal, just make sure that you do a good background check about that journal. And fake, in what terms you are saying fake? Like, I understood in a manner that maybe they have taken money from you for publication and then they have not published your paper. That is how I think that fake you are trying to say. Otherwise, I am not able to interpret that what fake you are trying to mean. If that's the case, what you are putting forward, my friend, then that is at most you can do. That you can, like file maybe a complaint against them or something. That's what you can do. That they ghosted away with your money. But even if that you will be able to do only if you can, track back them. That's what you can do. Yeah, moving, please. Next question.
I hope, Amrish, you have clear with your dots. And the next question is, what is literature review and what is its importance in preparing a revision manuscript?
Okay, so as I already said, that literature review is something to put it in a very easy language, that you are writing a paper on, how to reduce the crimes committed by juvenile delinquents in India. So for that, you will, refer to earlier works which are there on the said title, or the title near to the topic which you have chosen. You will read those manuscripts. You will try to deduce out some points from there. Maybe you will try to find out some issues which you haven't thought about before while writing a paper on this topic. Then you deduce those points and you put it in your own, you put that perspective in your paper through your own views. Or let's say at all that, the point which you are looking forward to, let's say you have some point in your mind that you want to discuss this point through this paper, or through the topic which you have chosen to write a paper on, and that topic to verify or to find out that whether there is already an information or a research available on the said paper, you do a literature review, okay, to save your time and to bring out something new to the readers or a new perspective all total from which is already existing.
All right, sir. Sir, another question which is very relevant for all the law student. Question is, as you know, a law student face difficulty reading plagiarism. So what tips would you like to give to law student to avoid plagiarism? That's you already covered in the session as well.
Yeah, I discussed in the session, but chalo, theek hai, I'll answer it once again, no problem. See, guys, plagiarism, firstly, the main point you should keep in mind is that whatever you are writing, for that, aapne jo bhi resource se, from whichever resource you have referred to and you have taken information from, read that information, process it in your mind, and then come up with something new. Come up with some new perspective on that, or try to put whatever you have read in your own words, and then try to write it. And wherever you are taking information which is already being mentioned by someone else, try to mention footnotes. Try to mention that particular information in footnotes from whichever website or whichever paper or work you have taken that information from. But never use the exact words, the exact verbatim, because even if you use the exact verbatim and you footnote it, it will still be counted in plagiarism, no matter what. Yes, Rehan.
Sir, another question is, which is, yes, sir. Sir, another question is, how important publication of paper is from the point of securing internship in first time law firm? Even everyone wants to know this, including me.
I was expecting this question. So see, guys, the point is that I will first issue a caution before I make any statement that even if you follow this method of this mantra, you will secure in tier 1 internship. I don't make any such claim. Okay. However, on the basis of my observation and whatever I have came across through my 5 years of journey in law school, that what all factors the HR of tier 1 law firms see while they see your publications is that firstly they see the topics. Like if you are applying at a tier 1 law firm in the disputes department, the dispute resolution or litigation, to put it precisely, and you have your publications in mergers and acquisitions, you have your publications in company law, in corporate law, you have 10 to 20 publications, but doesn't matter. They will straight away reject your CV because the thing which you are applying for and the papers, the domain in which you have written your papers are all totally different. Okay, so the first thing is that choose the topic wisely. If you are going for litigation, then for dispute resolution, publish papers or show the papers in your CV, only those papers which are related to that practice area in which you want to enter. That's number one. Number two is try to publish your papers if you can in the journals listed in UGC CAS list. But however, the thing is that, for undergrad students, it normally becomes difficult because mostly in UGC CAS list, I'm using the word mostly. Please understand, not all. Mostly in most of the journals, they actually accept submissions from assistant professors, or academicians. Very less journals, UGC listed journals are there who accept papers from undergrads. So that's one other hack you can do. Thirdly, while you are publishing your papers, just don't focus only on publishing papers. Publish blogs also. Okay, because on trending issues, because if by luck your CV goes to the partner of the designated practice area which you want to go into, so they will be, I think, they will be much happier if you have written a blog on a current trending issue on that topic. Like if you want to do on technology law or artificial intelligence, then publish a blog on artificial intelligence or bitcoins. Okay, on a blog, and if the quality of write-up is good and they are able to extract some information from it and they're able to understand that you have done a good substantial research and you have a basic knowledge on that, then they will definitely give you a chance. Then you definitely have a chance, or your application can be considered. Again, that depends on whether they have vacancy or not. But if you are expecting that in order to improve your CV from writing, this is the hack. Next question.
Sir, the last question, but not the least, and that's the compilation of all the questions from the participants. Sir, they really want to know that first year and second year law student, how to develop the legal research skill.
Okay, how to develop legal research for first and second year law students.
Yes, sir.
See, the thing is, guys, in most of the law schools in first and second year, I don't think that you have your core law subjects. You have constitution as a law subject, but apart from that, or maybe torts you have, or contract. I think these three law subjects come to my mind when you are in first year. Okay, or you might have international human rights and all those subjects you might have. So you don't get disappointed. You don't say yourself this, that as I haven't studied any law subject, I cannot write a research paper. No, that's the biggest red flag. Never do that. Always think that what issue you have in hand. You have socio-legal issues. You have read sociology in first year. Okay, second year you must have read sociology. Use those points. Try to relate those with the law subjects. I mean, if you have read about dowry death, okay, or death caused due to harassment for dowry or torture for dowry, then you don't need to know entire IPC. Write the sociological aspect, refer Indian Penal Code 498A and other, the important provisions which are there on the said subject matter. Refer those things, and then you imbibe it in your research paper. That's how. That's one of the ways you can improve your research. Secondly, if you are lucky enough and your law school allows you to do a, what should I say, a moot for that matter, do moots. Those moots help you a lot to improve your research. I mean, it's for me, I think it's the best way. It has proven that moots help me to, think in a different manner, to think deeply about or to do more of the legal research. That is moots for me. For others, it can be writing research papers, it can be presenting papers at the conference, having discussions with your, senior faculty members, your teachers in the college. It can be any of the ways. But I just shared my experience with you all. And apart from that, one more thing I did, because in first, second year, I really didn't got the scope. And to be really honest, I was, I was not actually taking the correct approach in the first and second year of my law school, because of which I could have been, clear the elimination rounds of my law college. But eventually from third year, I did, of course, as Rehan told in my introduction. So what I used to do is that I didn't used to sit back. I used to do, MUNs, because in MUNs also, you will be required to do a good research. Not exactly wholly on law points, but other points also. Like if you are interested in world politics, you are interested in geopolitics, or you want to know the scenario at the international level. If you are tomorrow thinking of going to UNO as an student intern or a student researcher, or as a you want to represent India in the UNO, so for you MUNs would play a vital role. Do MUNs. Okay, many people would say that your MUN experience doesn't count, but trust me, for that matter, if any experience is not adding anything to your skill set, that won't anyways add a value in your life. So don't go by people's thoughts. If you feel like that you're not getting a chance for a moot, you're not motivated to write a research paper or a blog, go for MUNs. So that's in a nutshell I could explain, for the initial year law students to do research. And make a habit of reading the legal news. Okay, if you're not very comfortable in reading case laws, read legal news. Subscribe Live Law, because Live Law, they attach the judgment also to their news, whatever they are writing, the news write-ups. But at the same time, you will see that before that they completely, summarize it in their own words. I mean, the 100 pages, 150 pages judgment, they summarize it in a few paragraphs in their own words. Read those paragraphs, so you will be able to get a good insight on that, and it will eventually help you to think, in an other perspective, and will help you to understand that, how should you proceed doing the research on the said topic.
All right, so this was the major concern.
Yeah. So I hope all the questions are answered.
Coming to the end.
I hope the questions are answered, Rehan, right?
I hope participants you have. Yeah, all right, sir.
Okay, thank you.
I hope participant you are clear with your doubts. And sir, so if there is no question, I think we can conclude the webinar.
Yes, I think we can close the webinar now. Like, if you have anything to say, please go ahead. And
on behalf of, yes, sir. I think there is last question, sir. Sorry to interrupt, but participant. Is the upcoming 4-day certificate course on legal research for first-year law student too?
Yes, it is. And if you want to know further details about it, you can, contact the person who is who is actually the managing editor of JLSR, Mr. Sai Vikrant Deshpande. His contact is there already on the group, so you can just contact him. He will tell you the further details.
Now we can conclude it, sir.
Okay, thank you, Rehan.
On behalf of Being Logical and JLSR General, we would like to express our heartfelt gratitude to Apratim De sir for joining us and making our time from his busy schedule. Session was extremely enriching and informative. Further, we also thank all the participants for being here with us. We hope to host you soon.
Thank you. Thank you, everyone.
Have a good.
Thank you, organizers. Thank you, participants, for giving me this platform. Thank you all.
Most welcome, sir.